completed. Because you completed it, oh God, we can gather today to celebrate their success. So we say thank you. Take your glory. Bless this land. Keep us, oh God. Sustain our lives. Sustain the peace. And whatever we do, oh God, let it be done to your glory and to your honor. For this, oh God, we pray. In your Son Jesus' name, we ask with thanksgiving. Amen. Thank you, all.
Mr. Clerk, call the first case.
The United Petitioner applicant for this listener by your attorneys, in fact, respondent petition for re-argument is called for judgment.
Madam Justice CNT Clinton Johnson will deliver the opinion of the court.
This is a case involving a petition for re-argument. This could have, on December 19, 2024, delivered an opinion which dismissed the motion, dismissed the appeal, dismissed the appeal. The petitioner before us in re-argument filed a petition for re-argument on grounds that we have overlooked a key point in making our decision that would have otherwise made us to decide for him. His contention was that we have put in our ruling that up to the hearing of the petition, the record had not been transcribed. Even though it was an inadvertence, but he had transcribed this record before the court October 15, 2024. 1 year, 11 months, and 13 days after final recommendation of judgment in the lower court. So this court holds that even without inadvertence, it doesn't change anything. He had abandoned his matter when he did not file and transcribe the record with the clerk of court in 90 days. Hence, our judgment.
Judgment.
This case was called for hearing. Councillor Haji Swahili ACC appeared for the petitioner. Councillor Mark and then Bobby appeared for the respondent. Having reviewed the records, heard the arguments and contentions advanced by the councils representing the parties, and considering the relevant laws applicable thereto, it is hereby adjudged. At Part 1, Rule 9 of the revised rules of the Supreme Court states that for good cause shown to the court by petition, a re-argument of a cause may be allowed only once when some palpable, substantial mistake is made by inadvertently overlooking some facts or point of law. The following our final judgment of December 19, 2024, the petitioner filed a petition for re-argument contending that the court had overlooked the fact that he had transcribed the records prior to the hearing of the motion to dismiss, and had the court considered that fact, the court could not have dismissed the petitioner's appeal. Although the judgment emanating from our opinion of July 19, 2024 stated that the petitioner had failed to transcribe the records up to the time of the hearing of the motion to dismiss. However, the opinion from which the ruling emanated did address the fact that the petitioner failed to transcribe the records within a statutory period of 90 days, but rather waited 1 year, 11 months, and 3 days after condition of the final ruling of the trial court. That more besides, this court addressed the issue of the insufficiency of the petitioner's bond, another ground for which the appeal was dismissed. Wherefore, in view of the foregoing, this court not having overlooked any fact or judgment of this court deliver on points of law, the petition for reargument is hereby dismissed. The clerk of this court is hereby ordered to send a message to the court below, commanding the judge presiding therein to resume jurisdiction over this case and proceed in accordance with the December 19, 2024 judgment of this court. It is hereby so ordered. Giving under our hands in the seal of the Supreme Court of the Republic of Liberia, this 18th day of February 2025. Signed, CNGO Chief Justice, Supreme Court of Liberia. James Edward Howard Wodokoli, Associate Justice, Supreme Court of Liberia. CNN D. Clinton Johnson, Associate Justice, Supreme Court of Liberia. Note, Mr. Justice Yusuf D. Kaba, having informed this court of the affiliation with one of the parties in this case, did not participate in the hearing of determination of this case, hence did not sign this judgment. Also note, Mr. Justice Yami Kokwekwe Senior, having presided and made determination in this case while serving as circuit judge, did not participate in the hearing and determination of this case, hence did not sign this judgment.
Number 2.
Mutual Benefit Assurance Company Informant of Honor given by the Morgan Chief Judge, respondent, other judges of the Commercial Court, first respondent, and Dear Mountain Mining Corporation, second respondent, bit of information is called for judgment.
Mr. Justice Yusuf D. Kaba will deliver the opinion of the court.
This is the second time this matter has been brought before this court. The first time it was an appeal from the Chief Justice's determination on the writ of prohibition. In that determination, the Chief Justice ordered that the petitioner in that prohibition should go back to the commercial court where the case was originally heard and perfect their appeal in keeping with law. When the matter went down to the commercial court, the petitioner again filed this bill of information, this time alleging that in 2015 there was another case that was before the Chief Justice, and in that case that is related to this case, the Chief Justice determined that the amount that was in conflict was a figure other than the figure that was involved in the case that the commercial court passed on in the action of debt. He therefore wanted the court to make the determination that that original figure should be the figure, the figure in the 2015 case should be the figure that should be used in determining the amount that's supposed to be deposited in the escrow account. The Supreme Court heard the matter and then determined that, look, in the first place, the 2015 case was different and distinct from the case that was instituted, from which the debt court entered judgment against the informant. And therefore, the petition, the information presented by the petitioner does not fulfill the office of information as provided for by the rule of the Supreme Court. So therefore, the Supreme Court denied the bill of information and ordered the matter to be sent back to the court below to proceed as provided for by law.
Judgment.
When this case was called for hearing, Councillor Aloysius T. Chapa appeared for the informant. Councillors Eugene L. Masipo and Kubuyon appeared for the respondent. Having heard the arguments, reviewed the facts and circumstances revealed by the records, and examined the law controlling the hereby judge, that Rule 4, Part 12A and B of the revised rules of the Supreme Court provides that, quote, in order for a bill of information to lie, a matter forming the basis of the information must have been pending before the Supreme Court or decided by it. There must be an act to usurp the province of the court. There must exist some irregularities or obstruction in the execution of the Supreme Court's mandate, or there must have been a refusal to carry out the Supreme Court's mandate, unquote. In the instant case, the bill of information filed by the informant concerning the 2015 Chambers Justice ruling having failed to state any of the conditions stipulated herein, the bill of information will not lie. Wherefore, in view of the foregoing, the bill of information is denied. The clerk of this court is ordered to send a mandate to the court below, commanding the judge presiding therein to resume jurisdiction over this case and give effect to this judgment. And it is hereby so ordered. Giving under our hands and the seal of the Honorable Supreme Court of the Republic of Liberia, this 18th day of February 2025. Signed, James Etta Howard Wodokoli, Associate Justice, Supreme Court of Liberia. Yusuf D. Kaba, Associate Justice, Supreme Court of Liberia. Yami Koko Perez, Senior Associate Justice, Supreme Court of Liberia. CNN D. Clement Johnson, Associate Justice, Supreme Court of Liberia. Note, Madam Chief Justice, CNN GO, having decided this case while residing in Chambers, did not participate in the hearing and determination of this case, and she did not sign this judgment.
Mr. Clerk, call case number 3. Councillors, who were the councillors for this last case? With mutual benefit. We need a slight editing of one of the pages now, so you can get it there. Mr. Clerk, call case number 3.
The Judicial Inquiry Commission report on complaint filed by Mr. Romeo Jala against Magistrate Abraham Simon is called for judgment.
Madam Justice, Chief Etta Howard Borokali will deliver the opinion of the court. Okay, the complainant, Romeo Jala, filed an action for theft of property in criminal court plea, alleging that one Fosi Sayer and his wife took $12,400 for a vehicle but failed to deliver or refund the money. Failed to deliver the vehicle or refund the money. The judge invited the Sayers and had them charged. The brother of Mr. Sayer, who is the magistrate, Magistrate Abraham Sayer, came in and acted as surety and made a promissory note to pay the money. They managed to pay $6,070 with a balance $530 left. Then the Sayers left. The brother Fofi Simon and his wife left the country, and the magistrate was called upon to pay the balance money. And the complainant said he kept going to the court, and couldn't get the magistrate to pay this amount. In fact, the magistrate made a statement to him, and I want to read the statement. And the magistrate said to him, nothing will come out of this complaint, and that he will pay the money like chicken change. So the complainant said he got time to go to the court, and he decided to write a complaint to the Chief Justice, who had this matter forwarded to the JIC. The JIC asked the respondent magistrate to write a deterrent or whatever to the complaint. And he went there and started talking about jurisdiction. The court didn't have jurisdiction. And in fact, they had decided to dismiss the power. And the complainant didn't want the car anyway. He went on. And the report that came from the JIC said that they found him that he had violated the rules 15. He had violated canons 14 and 13. He had violated canons 14 and 13, and so they made certain recommendations to the court to have him pay this money. But having reviewed the records and the testimony, this court has decided that Magistrate Sayer Abraham Sayer will be suspended for 6 months, and that he, in 3 months, must pay the balance $5,300. Sorry, he must pay it in 3 months because this court here, you have what the court being represented, and if you really take into account immediate lawyers, judges, all of you will say that you cannot treat the court with impunity, and parties coming to the court with impunity. And so, having violated these provisions of the canon 4 and 13, and if you read the opinion, we see what 4 and 13 is, we say that he is suspended for 6 months. And in 3 months, he must have the $5,300 returned or paid to the complainant. That's the short version of the opinion. Judgment.
When this case was called for hearing, because Kukuwata or Battle Homes from J. Awia Fantan and Tommy and Dubai appear as amnesty agreed. Because the Amara A. Kenan appeared for the respondent. Having carefully reviewed the records, heard the arguments, and considered the relevant ethical principles applicable thereto, is hereby judged. That the judicial canon states that a judge should not accept inconsistent dictates nor incur obligation, pecuniary or otherwise, which will in any way interfere or appear to interfere with his to the expeditious proper administration of his official duty. and that the respondent in his capacity as magistrate violated the canon when he signed as surety for his relatives. Hence, the finding and recommendation of the JRC be that he discharged. Wherefore, in view of the foregoing, the findings and recommendation of the JRC are affirmed. The respondent is suspended for a period of 6 months and has been later repaid an outstanding amount of United States $5,300 to the complainant within 3 months as of the date of the rendition of this judgment. The clerk of this court is ordered to inform the office of the court administrator and the parties of this decision, and it is hereby so ordered. Giving honor our hands in the seal of the Supreme Court of Liberia is the 18th day of February 2025. Signed, Tiaina G.O., Chief Justice, Supreme Court of Liberia. Chief Edward Howard Monopoly, Associate Justice, Supreme Court of Liberia. Joseph B. Kaba, Associate Justice, Supreme Court of Liberia. Lord, His Honor Associate Justice Yami Koku Senior, having chaired the Judicial Inquiry Commission in the disposition of this matter, recused himself from the hearing of this case, hence he did not sound this judgment. Also note, our Honor Associate Justice Nene D. Junior Johnson, having handled certain aspects of this case when she served as a circuit court judge, she recused herself from the hearing of this case, hence she did not sound this judgment. Urban Marketing Group Inc., Appellant versus John Hillary Tubman, I believe a few going on an objection to the report of the majority member of the Board of Arbitration is called for judgment.
When this case was called for argument before the court noted the absence of a counsel representing the appellant, and realizing or noting that the records show that both parties, that is the appellant and the appellee, had filed their respective briefs, and that this matter has been pending in our courts since 2003. The court invoked the requisite rule, and entered upon the records, hence this ruling. This appeal is from the 6th Judicial Circuit Civil Law Court, Montserrat County, where the present appellee have filed a petition to compel arbitration against the appellant with whom the appellee had entered a joint venture agreement. In that agreement, the paramount provision thereof and the consideration by the present appellee and the appellant was to the effect that the appellee, John Hillary Tubman, would give his parcel of 3.4 acres of land to the joint venture, and that the other party, now Urban Marketing Inc., would build a hotel and other facilities, and in that agreement they also decided percentage of money to be distributed among the partners. Suffice it to say, the agreement went awry, and that is why the appellee filed the petition to compel arbitration The trial court, upon receipt of that, they decided to call, in fact, not to call, but decided to alert the other party around the appellate and compel them to arbitration under clause 14 of the agreement. That is, anything in that joint venture agreement should go to arbitration. In fact, they went on so far to even state the method of the arbitration, that each one of them will name an arbitrator, and both of them will jointly name a chair of that arbitration board. And this was done after many prompting of the trial court to the appellant to cooperate in this case. The appellant finally went to arbitration, and we don't know what happened, but can you imagine from 2003 to the setting up of the arbitration board, nothing was done in this case there by either party until 2012. There was a meeting again of the arbitration board. The records are void again of what happened. It wasn't until 2018 again before there was any action with respect to the arbitration proceedings. But finally, there was an arbitration report filed with the trial court and an award given or made in favor of the present appellee. And that arbitration award said that the property of 3.4 of the appellee be returned to him, which was also part of one of the clauses in the arbitration agreement, and that he be paid all of the back pay that the appellant had failed to give him from the proceeds coming from the hotel. Of course, the appellant filed objections to the arbitration report, and the only thing on the award and the only grounds he gave was that the chairman of the arbitration board had allegedly not allowed his arbitrator to make a submission. What was the nature of that submission? The appellant did not say, but just generally said that because of that denial to submit this submission, that's on the basis of his objection. We all know mere allegations are not proof, and they remain mere allegations. Suffice it to say, the trial court, upon receipt of that, of course, can deny the objection and confirm the report of the arbitration team. So the appeal, the appellant appeal, and this court is affirming the award or affirming the final ruling of the trial court as contained in the arbitration report.
For this case was called for hearing, no lawyer appeared for the applicant. Councilors Joyce, Reeves, Booth, and Ambrose Tabla appeared for the appellee. Having entered upon the records and considered the evidence and the laws relevant thereto, it is hereby adjudged that the Constitution guarantees the obligation of contracts and prohibits the enactment of any law which may impair this right. And courts are under the duty to recognize, protect, and preserve the sanctity of valid and enforceable contracts. It is also the law when parties voluntarily submit their dispute to arbitration, the award thereof is binding and enforceable upon the parties, their heirs, executors, administrators, and assigned. It may only be vacated by the court upon written motion of the party on any of the grounds stipulated under Section 64.11, subsection 1 of the Civil Procedure Law. That the parties having agreed to submit their dispute rising under the joint venture agreement to arbitration, and there be no proof of the existence of any ground for vacating of the arbitration award as provided for under Section 64.111 of the Civil Procedure Law. The confirmation of the arbitration award by the trial court was proper and within the scope of the law. Wherefore, in view of the foregoing, the final ruling of the State Judicial Circuit Civil Law Court, Montserrat County confirming the award of the arbitration panel is affirmed. The clerk of this court is ordered to send a mandate to the court below, commanding the judge presiding therein to resume jurisdiction over this case and give effect to this judgment. Because I rule against the appellant, and it is hereby so ordered. Giving on our hands in the seal of the Supreme Court of Liberia, this 18th day of February 2025. Signed, Senior GDO, Chief Justice, Supreme Court of Liberia. Chief Edward Howard, Associate Justice, Supreme Court of Liberia. Yusuf D. Kaba, Associate Justice, Supreme Court of Liberia. Yami Boko, Vice Senior, Associate Justice, Supreme Court of Liberia. CNN D. Clinton Johnson, Associate Justice, Supreme Court of Liberia.
Mr. Clerk, call case number 5.
The Samuel Cover of the State of Oregon, the appellant of the Special Mantu, Yuda Koga, Abidi, appeal going out of petition for the processuary is called for judgment.
Madam Justice Sienna D. Clinton Johnson will deliver the opinion of the court.
This case involves a petition for divorce filed in a civil law court. When the divorce was filed, the respondent filed, the defendant filed for answer, and along with her answer, she filed a petition for alimony penalty. It was determined that her alimony penalty would be $1,000. Subsequently thereafter, the appellant in this case filed a bill of information informing the trial court that the respondent had left their home and taken everything out of the home and listed where it was. The trial court sent the sheriff to do an inventory and thereafter made a ruling to reduce the alimony from $1,000 to $200. So she came up to the Supreme Court on certiorari that the trial judge had made an error in the way he handled the issue of alimony penalty. We at the Supreme Court affirmed the $1,000 that was originally given to her by the trial court in the grade of certiorari. The appellant appealed to the Honorable Supreme Court. And the issues we discussed here was that it is a fundamental principle of law that there must be a hearing before a determination, and that a sheriff's inventory does not constitute a hearing, because the respondent had in her certiorari informed the court that had the judge heard the reason why she left the home, a matter that she had reported to the court. In fact, it would increase the alimony because the alimony was based on the fact that she was living home. And once she left the house, there was justification to increase it. However, the judge reduced the alimony without a hearing. Hence, our decision.
This case was called for hearing. No counselor appeared for the appellant, Councilor Roof, and Jabba here for the plea. Having entered upon the records and considered the facts and law without hereupon, it is hereby adjudged. And the Civil Procedure Law, Revised Code, that is 1 Section 16.21 states that, quote, certiorari is a special proceeding to review and correct the decision of official, board, or agency acting in a judicial capacity, or to review an intermediate or other or interlocutory judgment of a court, unquote. That section now continue of the Domestic Relations Law provides that, quote, in any action brought within a lifetime of both parties to the marriage to declare the nullity of the void marriage, or to annul voidable marriage, or for a divorce, the court may direct the husband, life, to provide suitably for the support of the wife as in the court's discretion justice requires. Upon the application of either the husband or the wife, upon such notice to the other party, and given in such manner as the court shall direct, the court may annul or modify any such direction as justice requires, unquote. And the trial court err when they proceed without hearing of the best information to sua sponte reduce the appellee's alimony. Wherefore, in view of the foregoing, the ruling of the criminal justice is hereby affirmed. The alternative rate issue is sustained in the peremptory rate of health. The appellant is ordered to pay the original alimony of $1,096 retroactively as of the date of the last payment. The clerk of this court is hereby ordered to send a mandate to the trial court providing the judge presiding therein to resume jurisdiction of this case and give effect to this judgment, and it is hereby so ordered. Giving on our hands in the seal of the Supreme Court of Liberia this 18th day of February 2025, which is signed Edward Howard Watercolor, Associate Justice, Supreme Court of Liberia. Yusuf D. Kaba, Associate Justice, Supreme Court of Liberia. CNN D. Clinton Johnson, Associate Justice, Supreme Court of Liberia. Lord Madam Justice, CNN G. Yo, having presided and made the determination in this case while serving in chambers, did not participate in the hearing determination of this case, hence she did not sign this judgment. Also note, Mr. Justice Yami Kwekwe Senior, having presided and made the determination in this case while serving as second judge, did not participate in the hearing determination of this case, hence he did not sign this judgment.
Mr. Clerk, call case number 6.
Jean Kosh Davis, appellant versus Mrs. Maria D. Johnson Youngwe, I believe the appeal where action of ejectment is called for judgment.
Mr. Justice Yusuf D. Kaba will deliver the opinion of the court.
This appeal rule of the action of ejectment, the hearing of which is dated in part of this case. The appellee here instituted this action against the appellant, claiming that the property upon which the appellant was residing was owned by her. And therefore, she was seeking to have the appellant boosted, evicted, ejected of the said property. The appellant answered to the complaint, alleging that whether I'm on this property by permission or some other person, I'm a caretaker on this property. But here is the person's deed. The appellant filed that answer, the appellee withdrew her complaint and then substituted the complaint, this time not with an ejectment action, but with the complaint in summary proceeding to recover possession of real property. And this amendment process was done after 10 days when the appellant had filed or answered. So the appellant filed an amended answer to the amended complaint and a motion to strike. Surprisingly, the trial judge did not hear the motion to strike. Then the motion for the investigative survey was introduced into the matrix. The surveyor again went to conduct this investigative survey, but the surveyor refused to take into consideration the title instrument of the appellant. Conducted the survey and came up with a report that the appellant was encroaching on the appellee's property. That is, without taking into consideration the appellant's title deed that was pleaded with for answer. Going further, the actual owner of the property that the appellant alleged placed on the property came when the trial has started. So this actual owner again filed a motion to intervene. Again, this motion of intervene was ignored by the trial judge. The trial judge proceeded with the trial, and at the end of the day, entered judgment, entered a ruling, holding the appellant liable and ordering that the appellant be boosted, evicted, from the property. This court decided to reverse the final determination of the trial court and order the entire proceeding ended. In leaving to the party the liberty to file the appropriate action to defend their property interests. And this was our judgment.
When this case was called for hearing, Councillor Thompson Java appeared for the appellant. Councillor Felicia V. Coleman appeared for the appellee. Having heard the arguments, reviewed the facts and circumstances revealed by the records, and examined the laws controlling the judicial arbitration. Article 20A of the 1986 Constitution provides that no person shall be deprived of life, liberty, security of the person, property, privilege, or any other right except as the outcome of a hearing judgment. In the instant case, the judge erred when he ignored the motion to intervene and the motion for new trial filed by the appellant. Wherefore, in view of the foregoing, the final ruling of the judge is reversed and the entire action further abated. The parties are at liberty to find an appropriate action to defend their property rights. The clerk of this court is hereby ordered to send a mandate to the court below, commanding the judge presiding herein to resume jurisdiction over this case and give effect to this judgment. Because this allowed, it is hereby so ordered. Giving under our hands in the seal of the Honorable Supreme Court of the Republic of Liberia, this 18th day of February 2025. Signed, Siene G.O. Chief Justice, Supreme Court of Liberia. Chief Edward Howard Wolopoli, Associate Justice, Supreme Court of Liberia. Yusuf D. Kaba, Associate Justice, Supreme Court of Liberia. Yami Kodbo, Senior Associate Justice, Supreme Court of Liberia. Senior Eklino Johnson, Associate Justice, Supreme Court of Liberia.
Clerk, call case number 7.
Grievance and Ethics Committee report on complaint filed by Judicial Reliefs and Judicial Chairman against Councillor Jones and Human is called for judgment.
Madam Justice, Chief Inspector Howard Worokoli will deliver the opinion of the court.
The complainants, this is Petition A. Reeves and the chairman, filed a complaint with the Chief Justice, alleging that Councillor Jones Sadman had entered the matter and had not accounted for the proceeds that he received. The facts are, they came back and found that there were people illegally encroaching on the property at the airfield, and that they got the law firm that Councillor Newman was in to handle the matter. Councillor Newman said that he handled the matter along with Councillor Booth, and that they had a meeting, and the meeting that they had with the clients, some people had already developed the property. So because they had developed the property, they asked to pay for the land on which the property, the piece of land, each one of them had the property on piece. And they asked to pay for that portion of the property. And they all agreed. So those who agreed came to pay the money at the law firm where Councillor Newman was. And those who didn't agree took to court. Now those who agreed to pay came and paid. They made stipulations and came to pay. And Councillor Newman admitted that the money was paid to the secretary, or sometimes him, if he were in the office, or paid to him if he was in the office of the secretary. He also said that he left the law firm, the first law firm, and went to another law firm, and these people decided to retain him, to keep him on the matter, and so he continued to collect the money, and so they pay again to the secretary of the second law firm, and sometimes when he was there, he received the money. But the fact of the matter is that at a point, he could not account for the total amount of what he collected, and the people said they kept calling, and you know the lawyers, when they call you, they don't answer. They kept calling, and so they decided to write to Chief Justice, who sent the matter down to the GEC, the Grievance and Ethics Committee. And Councillor Newman admitted that he did not properly supervise the handling of the client's funds, in that to see what was paid at the end of the month, what was remaining, how much he deducted. He deducted, but he didn't make sure what was the balance. So the GEC called for them to settle the matter, both get an accountant, you get an accountant, come together, and let's see what the balance is. And so they went back and forth, and finally it was concluded that there was an outstanding amount of $6,320. Outstanding amount of $6,320 that was supposed to have been paid to the complainants. So the GEC advised all the group and reported that Councillor Newman paid this money. Councillor Newman said yes, he admitted that he didn't properly supervise the secretaries that were collecting the money and blah blah blah. So the court has agreed with the ruling of the GEC, and the court says to Councillor John Sadman that you are ordered to refund the accountable amount of $6,300 forthwith. The court is saying that those of you who collect clients' money and do not carefully manage the money so that you pay them all the money, the court says this is something we will not contest. Forthwith, you should pay the money. That is the judgment. and did not.
When this case was called for hearing, Bakakoro Farmer, J. Awea Franka, Kukuwa, Dr. Tommy Edova, here as Amicis Green. Because the attorney being Mason appeared for the respondent. Having carefully reviewed the records, heard the arguments, and considered the relevant ethical principles applicable thereto, it is hereby adjudged that Rule 15 of the Code for the Moral and Ethical Conduct for Lawyers provides that money or property coming into the lawyer's possession as a result of a lawyer-client relationship should be reported and accounted for promptly, and should not, under any circumstances, be co-mingled with his own or be used by him, and that the records having established that the respondent's client's funds were co-mingled with that of the respondent's offices, and he would not account for $6,320 of the funds to the post-provision of the funds of both his law friends. He is in violation of Rule 15, and therefore this court will not disturb the final recommendation of the GEC. Wherefore, if you are foregoing the findings and recommendations of the GEC are affirmed. Councilor John's argument is ordered to refund the unaccounted amount of $6,320 forthwith. His failure to comply with this order, he will be suspended from the practice of law. The clerk of this court is ordered to inform the parties of this decision, and it is hereby so. Giving on our hands and seal of the Supreme Court of Liberia, this 18th day of February 2025. San Selena GEO, Chief Justice, Supreme Court of Liberia. Chief Edward Harold Protocol, Associate Justice, Supreme Court of Liberia. Joseph B. Kaba, Associate Justice, Supreme Court of Liberia. Yami Kwekwe Maise, Senior Associate Justice, Supreme Court of Liberia. CNN D. Clement Johnson, Associate Justice, Supreme Court of Liberia.
Mr. Clerk, please call the next case.
Judicial Inquiry Commission report on complaint filed by Mr. Flaman and Tama against Magistrate Eric and Cooper of the Pennsylvania Judicial Court is called for judgment.
It is a standing principle of law that every court, to include the Supreme Court, must take cognizance of its jurisdiction before becoming seized of any matter filed before it or brought before it. And there is a typical example. The present complainant had filed a complaint before the Judicial Island Magisterial Court some time back. And he first filed it before one of the magistrates there, who was reassigned to another magisterial court, and the present respondent, Magistrate Eric Cooper, took over the matter. And the matter was a criminal one that not the county attorney, the city solicitor determined was theft of property by deceit. Theft of property by deceit. So after a while, nothing could be done about his matter before the court. The present complainant brought a complaint to the office of the Chief Justice, who forwarded it to the Judicial Inquiry Commission for an investigation. So his complaint basically stated that Magistrate Eric Cooper, who had taken on the case, had failed to have the gentleman or the administrators of a certain intestate estate gave him a deed to certain property that he had paid for, and these administrators had refused to give him the deed for the property that he had paid for. And this was the matter before the Ministerial Court that the city solicitor termed as theft of property by deceit. We continue to admonish magistrates, and particularly city solicitors who are operating in magisterial courts, to stop criminalizing civil matters. Because somebody came on, gave me my deed for property that I paid for, that basically theft of property by deceit. The people retained their property, they just didn't give it over. Is that theft of property by deceit? And we said we will take this for lawyers who go and do these things, especially our city solicitors, who, by the way, let me announce, they are not employees of the judiciary. City solicitors are employees of the Ministry of Justice. They are the prosecutors in the magisterial courts. Now, back to the case. So when Magistrate Cooper, legally, he could do nothing about this case. He kept on and delaying. That's what prompted this complainant to come with a complaint to the Supreme Court here to say that the magistrate had failed to do it, and moreover, when we send the matter down to the JIC to investigate, the JIC, instead of looking at the matter and right away making a determination that this matter was outside of their jurisdiction, mandated Magistrate Cooper to go ahead and find these people, these culprits, and force them to issue a deed in favor of the complainant for the money that he had paid for certain parcel of land. So all this court is saying that both Magistrate Cooper and the JIC did not take cognizance of their lack of jurisdiction in this matter, and moreover, the JIC recommended that we forward the case to Criminal Court A. We will not. It is not within our purview to do for parties what they should do for themselves. You already lack jurisdiction, so that is where we are going to stop. But notwithstanding, we are saying to the complainant, you are at liberty to pursue the requisite action to make these people give you a deed for property that you paid for.
For this case was called for hearing councilors J. Awia Banka, Kukuwa Double, Bado Holmes Mama, and Tommy Dubai appeared as amicus curiae. No counsel appeared for the respondent. Having carefully reviewed the records, heard arguments, and considered the relevant ethical principles applicable there, it is hereby acknowledged that it is the law that courts of law, to include the Supreme Court and other judicial forums, must of necessity take cognizance of the jurisdiction that prescribed by law, since the lack of jurisdiction renders a judgment therefrom void regardless of the consent of the parties. That in a distinct case, both Magistrate Cooper and the Judicial Inquiry Commission (JIC), having proceeded beyond their jurisdiction by hearing a case involving a failed real property transaction between private parties, and a judgment emanating from their respective actions is void ab initio as a matter of law, and that a complainant is at liberty to file the appropriate legal action before the proper legal forum protect his interests. Wherefore, in view of the foregoing, the findings and recommendations of the Judicial Inquiry Commission, JIC, are hereby reversed. Although the respondent magistrate has since retired, he is exonerated from the allegation level against him. The clerk of this court is ordered to inform the parties of this decision, and it is hereby so ordered. Giving on our hands in the seal of the Supreme Court of Liberia, this 18th day of February 2025, signed Syrian G.O., Chief Justice Supreme Court of Liberia, Yusuf D. Kaba, Associate Justice Supreme Court of Liberia, Yami Kokobaise, Senior Associate Justice Supreme Court of Liberia, CNN D. Criminal Johnson, Associate Justice Supreme Court of Liberia. Lord, Madam Justice Chief Peter Howard Woodcock did not participate in the hearing and determination of this case, as the appeal emanated from the report by the Judicial Inquiry Commission, JIC, whilst serving as its chairperson. Hence, she did not sign this judgment.
And councillors, just in case some of you are wondering, because some of you, in fact, most of you were not here yesterday, we announced that Mr. Justice Yami Kwekwe Senior would deliver all of his opinions on yesterday, as he had to urgently travel out of the country today. So although he's not here, he signed the other judgments. So don't think that he's not here and how he got to sign the judgments. He signed them before he left, okay? Mr. Clerk, call case number 9.
Consolidated Group in Affidavit for the
I said, we're here to do business. Please. We got around 16 cases here, so just relax, okay? You all always complain that the bench is lazy. Oh, we're showing you now. Yesterday was 25 cases. Today that's 16. We wanted to make it actually 75 cases. Mr. Justice Yusuf D. Kaba will deliver the opinion of the court.
Rule out of action from damages for wrongful attachment instituted by the Consolidated Group Incorporated against Nanasat Digital Television Communication and others. Basically, the appellant, Consolidated Group Incorporated, averred in his complaint filed with the commercial court that she hold a representative agreement from Multi-Choice Africa and Super Sport to oversee their content rights in Liberia. And that content rights, like a copyright, is for screening live broadcasts of the English Premier League and the Spanish football, La Liga, football games, and others. The appellant alleged that the appellees, without authority, infringe upon their content rights by broadcasting these sporting events on their satellite screen without authority and provision from the appellant's principle, multi-choice and super sport. The appellant therefore alleged that as a consequence of this action by the appellees, the appellant suffered injury for which damages were liable. They prayed the court to award to them damages totaling 5.1 million United States dollars for the infringement on their content rights by the appellee. The appellee appeared, they answered, they said, well, look, in the first place, you do not have the standing, the capacity to institute these proceedings. Because these content rights are not owned by you. You are only an agent to broadcast portion of the content right, and you are not the owner of the content right. And as a consequence, you do not have the capacity to institute this action against us. More beside, we have authority from the Liberia Telecommunication Authority to operate in Liberia, and therefore we are not in violation of any law that will make you to hold us for infringing on your content right. They also challenge the damages that multi-choice prayed for, saying that, look, multi-choice, you said that you have incurred damages in this amount. But we checked at the Liberia Revenue Authority, and we saw your income tax returns that you filed with the Revenue Authority, and that return shows that you have been making hefty profit. Then how come you will come now and present an unaudited financial statement as the basis to claim damages against us? So therefore, we believe that even if you had a right to institute this action, the damages that you are praying for, they are not supported by the environments in your complaint. The appellant filed a reply. They basically reaffirmed all of the environments in the complaint, and the matter went to trial. At the end of the trial, the commercial court ruled that the appellant actually lacked the capacity to institute the action because the content rights were not owned by the appellant, and therefore the appellant would not have come and institute the actions that was before the court. We also agreed with the appellant that the appellant averments of damages was contrary to the evidence that were adduced at the trial, and therefore even if the appellant had the capacity to institute the action, the appellant cannot prevail to get damages from the appellant. From this ruling, the appellant accepted and announced an appeal to this court. Now, the first issue that this court looked at was the issue of the capacity, because before you can go to the substance of the case, you will first determine whether the party had capacity to institute the action in the first place. When we review the records, we saw that the appellant had entered a representative agreement with the multi-choice and multi-choice corporation and super sport. And among other things, the multi-choice and super sport confer upon the appellant the right to institute action on their behalf for violation of the content right that they enjoy in Liberia. In other words, the representative agreement gave the appellant the authority to oversee the content right of multi-choice and super sport in Liberia. And in our own opinion, with that provision in the representative agreement, the appellant did not need any power of attorney or any other board resolution to be able to institute this action against the appellee for the infringement on the content rights of the appellant's principle. And because they didn't have a right, this is an intellectual property. And the violation of that right can attract an injunction, an injunctive, a permanent injunction to stop the violation. So this court agreed that an injunction was necessary to be placed on the appellees from further violating the content rights of the appellant's principle. On the issue of damages, the court found that this matter was filed in the commercial court, and damages require the taking of evidence, and our law provides that evidence of that nature must, as a matter of right, be presented to his jury to make that determination. The commercial court, as an institution, lacks the competence to review those kind of evidence. So the court refused to delve into the issue of damages and left to the party the liberty to institute an action in the appropriate forum if they so desire. So that, in essence, was the finding of this court.
Well, this case was called for hearing. Councilors Andrew Stapler, Morris M. Davis Jr. appeared for the appellant. Councilor G. Wilfred Afro-Sai appeared for the first appellee. Councilors Eugene Bassett and Anthony D. Mason appeared for the second appellee. Having heard the arguments, reviewed the facts and circumstances revealed by the records, and examined the laws controlling editorial judge, that in the face of clause 17.6 of the Code of Court Representative Agreement, which authorized the appellant to institute action against the violator of its principal's contents right, the appellant needed no board resolution for its principal for the institution of the action. Hence, the trial court committed reversible error when it held that the appellant lacked standing to institute the action of damages. That the evidence overwhelmingly establishes that the first appellee knowingly and with impunity violated the rights, the contents rights of the appellee's principal for authority to the injury and detriment of the appellant. Hence, the first appellee is prohibited and enjoined from broadcasting such protected contents of the appellant's principle as established by the evidence, and that the court having determined that the appellant has standing to institute the action of damages for wrong by attachment, the commercial court settled without the jury to award damages. The appellant is at liberty to pursue claim to damages at the appropriate legal forum. Wherefore, if before going, the final ruling of the commercial court is reversed. The clerk of this court is hereby ordered to send a mandate for the court below commanding the judge presiding therein to resume jurisdiction of this case and give effect to this judgment, because I rule against the first appellee, and it is hereby so ordered. Given under our hands and seal of the Honorable Supreme Court of the Republic of Liberia, this 18th day of February 2025, signed, Seyimen G.O., Chief Justice, Supreme Court of Liberia. Chief Senator Howard Wolokoni, Associate Justice, Supreme Court of Liberia. Joseph D. Kaba, Associate Justice, Supreme Court of Liberia. Yami Gungwe, Senior Associate Justice, Supreme Court of Liberia. C.N.A. Clinton Johnson, Associate Justice, Supreme Court of Liberia.
Clerk, call case number 10.
The Grievance and Ethics Committee follow up complaint filed by Mr. J. Odasia Kefula against Anthony Tiklo Maxwell Bristol. It's called for judgment.
Madam Justice Chinsetta Howard Wolokoli will speak on behalf of the court as soon as these late councillors can find their seats. But Councillor James, you go down there. See your councillors there. You see any young councillor there, take them from there.
Go ahead. The former military personnel of the Armed Forces of Liberia, actually, Tiklo Maxwell Bristol II, is chairman of the Liberia, or was the chairman of Liberia National Commission on Small Arms. A complaint was brought against him by a former military officer, Mr. Kekula. Mr. Kekula said he had his arm and wanted to be a good citizen. He decided to go and take the arm to be registered with the small arms. So he got there and he gave the arm. When he went trying to get the arm back, he said that Attorney Grace Perry refused to give him the arm. His officer said to him that the arm was it was illegally held by him. He should not have had it. In other words, they have not lifted the sanction of us having arms. So he took it, kept it. He said he kept going there, and Attorney Grace told him that you can take me anywhere, you go anywhere. Here I'm following the rules. You're not supposed to have arms, and you're not giving me your arms back. So he wrote to the Chief Justice. Came to the Chief Justice sent the letter down there to the GEC. And the GEC said, yes, you know, gotta be careful now. Not every lawyer that are working here on the street, that are working all around the place, when they have problems, then you come to the GEC or you come here. It's not the intent of the GEC. And we have here the intent. We just saying to you, this is not, and that's what the GEC said. The man acted in his administrative capacity at the Small Arms Commission, and that was not something that could be investigated. That could be investigated by the GEC. And we agree. If you have serious problem with the Ministry of Health, minister who is, the person happens to be a lawyer, you come here, you go to the person that has those sites, over administrative or GEC. So the GEC dismissed the matter, and we upheld the GEC report and recommendation that that matter is not a matter to be handled by us at the GEC. And so it's as simple as that. So he should go to the appropriate authority.
Well, this case was called for hearing councillors Bato, Kuro, Mama, J. Awia Franca, Uwadoba, Tommy Endoba, P.S. Amisis Kure, Councillor Jimmy Sabuma of the Central Law Office, Inc., appear for the respondent. Having carefully reviewed the records, heard the arguments, and considered the relevant ethical principles applicable thereto, it is hereby adjudged that the Grievance and Ethics Committee, GEC, shall have jurisdiction over and shall inquire into and consider any complaint made against any practicing lawyer involving his character, integrity, professional standing, or conduct as a member of the bar. And that though the respondent, Tito Magistrate President, is a practicing lawyer, the complaint brought by the complainant CWOJ Odasia Kekula, which alleges an administrative action taken by the respondent in his capacity as chairman of the Liberia National Commission on Small Arms, does not denote a legal ethical transgression. Hence, is not cognizable before the GEC. Wherefore, in view of the foregoing, the finding and recommendations of the GEC are affirmed. The clerk of this court is ordered to inform the parties of this decision, and it is hereby so ordered. Giving honor our hands in the seal of the Supreme Court of Liberia, this 18th day of February 18, 2025, signed Serene G.O., Chief Justice, Supreme Court of Liberia. Chief Edward Howard Wodokoli, Associate Justice, Supreme Court of Liberia. Yusuf D. Kaba, Associate Justice, Supreme Court of Liberia. Yami Okwe, Senior Associate Justice, Supreme Court of Liberia. CNN D. Clinton Johnson, Associate Justice, Supreme Court of Liberia. The Grievance and Ethics Committee report of being filed by Mr. Samuel Y. Johnson against Councillor Wafi Cannon is called for judgment.
The Chief Justice, you will read on behalf of the bench.
The present complainant, Mr. Samuel Y. Johnson, complained that Councillor Murphy County solely for failing, or what he called failing to assign the case that Councillor County had allegedly filed against him at the Monrovia City Magisterial Court. The facts show that Mr. Johnson a writ was issued against him for felonious restraint against the client of Councillor Cannon. And his thing there is that it had taken a considerable length of time, and Councillor Cannon had failed to get an assignment of the case to be heard against him. Now, we all know felonious constraints, even if a private lawyer is associating with the state. It is the state's prerogative to go get an assignment, but he was blaming Councillor Cannon for the non-assignment for the hearing of his case. And that is the crux of his thing, right? And I want to quote, he said, I am kindly asking the office of the Chief Justice to prevail on Councillor Cannon to assign my case at the Monrovia City Court. So what are we saying here? We say there is nothing unethical about this. In fact, he too was at liberty through his counsel or by himself to go and get an assignment of the case. and Councillor Cannon cannot be heard personally to answer for non-ethical situation that he has no control over. So that is our judgment on this.
Well, this case was called for hearing Councillors J. Awel Manskan, former attorney general, appeared as amici curiae. No counsel appeared for the respondent. Having carefully reviewed the records, heard the arguments, and considered the relevant ethical principles applicable thereto, it is hereby adjudged that the Ministry of Justice, under the authority and supervision of the Attorney General, Minister of Justice, is charged with the statutory duty of procuring the necessary pieces of evidence to institute all legal proceedings on behalf of the government of Liberia. That in the present case, the failure of the Ministry of Justice to procure notice of assignment for the hearing of a criminal action of felonious restraint filed against the complainant, which is the sole prerogative of the state, cannot be attributable to the respondent, Councillor Murphy Cannon, nor is seen an ethical violation for which Councillor Cannon may be reprimanded. Wherefore, in view of the foregoing, the report of the Grievance and Ethics Committee, GBC, dismissing the complaint against Councillor Murphy Cannon is hereby affirmed. The clerk of this court is ordered to inform the parties of the decision that it is hereby so ordered. Giving on our hands and seal of the Supreme Court of Liberia, this 18th day of February 2025, signed the G.O. Chief Justice, Supreme Court of Liberia, Chief Edward Howard Wolcott, Associate Justice, Supreme Court of Liberia, Yusuf B. Kaba, Associate Justice, Supreme Court of Liberia, Yami Boto Senior, Associate Justice, Supreme Court of Liberia, CNN Clinton Johnson, Associate Justice, Supreme Court of Liberia.
Mr. Clerk, did you serve Councillor Cannon with the assignment for today? Mr. Marshall, was Mr. Councillor Cannon served? So, that's it. Who signed for it? He himself signed. Is there any excuse from Councillor Cannon? Then, accordingly, Mr. Clerk, as per the precedent set in our rebranding, a lawyer's failing to appear to receive rulings in this court, Councillor Cannon is fined the amount of $300 United States to be paid within 72 hours as of the rendition of this judgment. Call the next case.
The Republic of Liberia, by and through the Ministry of Justice, was appellant in 107 and Barawood Resident Judge, Criminal Criminalizing. The second appellant was James Colley of the Mora Central Prison. I believe the plea were the Judicial for the session hearing is called for judgment.
Mr. Justice Yusuf D. Kaba will deliver the opinion of the court.
The Republic of Liberia, back into the Ministry of Justice, the appellant hearing charged in the grand jury of Monserrado County find an indictment against James Colley of the city of Monrovia for the commission of the crime of rape. Subsequently, the trial was hard, and it resulted into a hung verdict. 7 out of the 12 members of the petty jurors voted not guilty in favor of James Colley. The trial judge ordered But before the new trial could start, Mr. Collin, the appellee here, filed an application with the court for admission to bail. The trial court, after reviewing his application, denied his application, and Mr. Collin, not being satisfied with the action of the trial court, fled to the chambers of this court with a petition for a writ of certiorari. Our learned colleague that at the time presided in the chambers of the Supreme Court ordered the writ issued, conducted a hearing, and basically held that from all indication, the fact that 7 out of the 12 members of the impaneled jury can come up with a decision that the appellee was not guilty, that satisfied the condition under section 13.1 of the Criminal Procedural Code that indeed the proof is not evident and the presumption not great that the appellee, Mr. Collin, committed the crime, and therefore Mr. Collin was entitled to a bail as a matter of right. The Republic, the appellant, very dissatisfied with that determination by our colleague, appealed therefrom and brought this court for review before the full bench of the Supreme Court. The full bench, after thoroughly reviewing the records and taking due cognizance of the applicable law, determined that indeed section 13.1 was applicable in this matter, and that the applicant, Mr. James Collin, was entitled to bail as a matter of law. That was our determination.
Judgment.
This case was called for hearing Councilors T. Joseph E. Anthony Conley, William O. Johnson, and Desmond B. Dwight of the defendants here for the appellee. Councilors Augustine C. Fire, Solicitor General of the Republic of Liberia, as a judge, Judicial Justice here for the appellant. Having heard the arguments, reviewed the facts and circumstances revealed by the records, and examined the laws controlling it is hereby adjudged. That section 13.1.1 of the Criminal Procedural Law states that, quote, a person in custody for the commission of a capital offense shall, before conviction, be entitled as of right to be admitted to bail unless the proof is evident or the presumption great that he is guilty of the offense, quote. But while a grand verdict returned by a jury in which 7 out of the 12-member panel of jurors voted not guilty in favor of a criminal defendant, I believe, is not tantamount to an acquittal. It, however, supports the presumption that proof is not evident or the presumption that the defendant is guilty of the crime of rape. Hence, I believe, while not acquitted, is entitled to bail. Wherefore, in view of the foregoing, the ruling of the Chamber of Justice is affirmed. The alternative rate issue is upheld and the preemptive rate is sustained. The clerk of this court is ordered to send a mandate to the court below, commanding the judge presiding therein to resume jurisdiction over this case and give effect to this judgment. And it is hereby so ordered. Giving on our hands in the seal of the Honorable Supreme Court of the Republic of Liberia, this 18th day of February, 2025. Signed, Siine G.O., Chief Justice, Supreme Court of Liberia. Chief Senator Howard Wolokoli, Associate Justice, Supreme Court of Liberia. Yusuf D. Kaba, Associate Justice, Supreme Court of Liberia. CNN D. Kingdom Johnson, Associate Justice, Supreme Court of Liberia. Lord Mr. Justice Yami Kwekwe, Senior, having decided this case while presiding the chambers, did not participate in the hearing determination of this case, hence he did not submit to judgment.
Call case number 13.
The Judicial Inquiry Commission report of complaint filed by Inspector D. Clinton against his Court of Tenants, people, Judge of the Probation of Government Public Court, Sando County, is called for judgment.
Madam Justice James Etta Howard Wolokoli will deliver the opinion of the court.
This derives from a complaint brought to the Chief Justice that she had forwarded to the JIC. And it's a complaint against His Honor Octavius B. Doe, Judge, Professional Monday and Probate Court, Simon County. Inspector D. Clinton of the Yaku Public Depot filed a complaint against Judge Doe, and he said that Judge Doe had a habit where minors were supposed to take away certain amount of money each month, and apparently this minor, that M-I-N-E-R, this person of mine, whatever, this minor refused to follow the decision to take the Judge Doe. And so Judge Doe called him in and asked why he had not paid some $50,000. He had refused to pay his money. And so he had the minor taken to the police station and told the police commander that they complained that he should be jailed, that the minor will be jailed. So after staying there for some time, according to the complaint, the police commander said, called the judge several times. He didn't answer because he kept saying, look, this man is not well, this man is here, and he needs to get out of here. He needs medical treatment. Not having, according to the commander, he called the superintendent. And the superintendent gave the thing, say, let him get out and go to jail, I will go to hospital. Judge Doe heard about that, came and sent some order to have the man taken from just to make sure now. He told his sheriff or police, whatever he had there, say go and bring the defendant, let him come to the court. The defendant came. When the defendant came back and said the man had been released, so he said, okay, go and bring now the police commander. They went, he cited the police commander, he came, and when the commander came, some official put up in the court. And according to the complainant, they beat him up. The judge had them beat him up, tear his clothes, whatever it is. And so in the end, he had to go to the hospital. So he brought a complaint to the Chief Justice. The Chief Justice said the complaint down to the JIC. The JIC asked the judge, the responding judge, to respond to the allegation made in the complaint. And he came back and said, no, it wasn't so. I had sent this person to jail. And in fact, This man caused the people, the pepper boys to come in the church, to come in the court, and they came in the court and they misbehaved, and then the police director himself came, and police commander himself came, and grabbed him, put him in pickup, what they did to him, what they didn't do to him. But that's not the issue for us, because if the matter entering for us, we say, we should have written the Chief Justice to take it up with the Justice Ministry. What was brought before us was his behavior towards the police commander when he had this man released. And it was investigated by the GIC. The GIC, having investigated him, found out that he violated so many of the codes. Our canons, canon 5, canon 8, canon 13, canon 15, particularly canon 15. So they made a recommendation to this court. Let me see what the recommendation is. But they made a recommendation to this court, and they said to the court that if possible, we should have him removed or sent somewhere else. And that, okay, let me see what he has said. But anyway, in all, they said that his behavior was wrong and was so bad, his conduct from the investigation. So we look at it, where we had the amnesty period come, and they themselves said yes, his behavior was bad, and that although these people did this, they did that, was wrong. Everything what we did, because the man brought evidence. He brought evidence, pictures and all that. He said it threw in the back, the back of a truck, and all these things. We were saying no complaint or file before this man brought his complaint, and there was, it's evidence that we have to decide our case is on. And so we decided that because of the behavior of this particular judge, because he and the clerk came, what was the money for? He said that he was we were taking care of somebody's property. And so the man was supposed to pay if he was doing mining on the property of the person was supposed to pay to him. And the guy came with another story that is in opinion that was different from what he said. So having found out all that, we said that he violated the canons, particularly canon 35. And so in this regard, we are saying that this judge is suspended for 1 year. 1 year without salaries, benefits, and other emoluments. All corporate matters, by corporate judge, all corporate matters, if any in that Sando County district, they should be forwarded to the third judicial circuit for hearing during a suspension. And this is the ruling of the court.
When this case was called here, as Benedict Epsilon, Denise S. Sokan, Google White, Double and Luscious, Jabba here as MC3, as the Fester K will appear for the respondent. Having carefully reviewed the records here, the arguments to consider the relevant ethical principle applicable thereto, it is hereby admonished that the conduct of the respondent judge in incarcerating the complainant and ordering the brutal beating of the complainant on the premises of the court was in violation of the judicial canon. And that the actions of the respondent judge, though constituted a reprehensible violation of multiple judicial canons, particularly Judicial Canon 35. Hence, we would like to share the funding and recommendation of the JRC. Wherefore, in view of the full with the funding and recommendation of the Judicial Inquiry Commission, I confirm with modification that the responding judge is suspended for a period of 1 year for salary, benefits, and other emoluments. All probate matters, if any, shall be referred to the Third Judicial Circuit Court of the county with a period of a suspension. The clerk of this court is ordered to inform the office of the court administrator and the parties of the decision of this court. It is hereby so honored. Give the honor of hands in the seal of the Supreme Court of Liberia this 18th day of February 2025. Signed, Chief Editor Howard Wondercom, Associate Justice, Supreme Court of Liberia. Joseph B. Kaba, Associate Justice, Supreme Court of Liberia. Yami Koko, Senior Associate Justice, Supreme Court of Liberia. Senior D. Kendall Johnson, Associate Justice, Supreme Court of Liberia. Lord of Honor, Chief Justice Union G.O., having chaired the Judicial Inquiry Commission when she was Associate Justice, recused herself from the hearing of the case, hence she did not sign this judgment.
This is call case number 14.
Judicial Inquiry Commission report not open filed by pressure against Magistrate. Having filed against Magisterial Court, is called for judgment.
Madam Justice CNMT Clinton Johnston will deliver the opinion of the court.
This case is one of those cases in which the management of a magisterial court is placed before this court. This is a matter in which the complainant was renting in a house. She had paid her rent for 1 year. 2 months into the payment, the person from whom she rented the house went to her and told her that the owner of the house was coming back to Liberia and had requested particularly that she wanted to stay in her house while in Liberia. And she asked, so what happens to my 10 months that is remaining? And so they called her to the police station. She felt she was going to be threatened by the fact that now the Ministry of Justice were involved to ask her to turn over the keys and all of that, all in reference to the payment of her money before she turns over the keys. She was told at the police station to turn over the keys and then she would be paid. Not being satisfied with that position, she went to the court. When she got to the court, her case was assigned to Magistrate Faculty Ayan. And before Ayan, they agreed that she would turn over the keys to the court, and the court would keep the keys until the landlord paid the 10 months. So she turned over the keys. When she went back to find out whether her rent, the balance of the rent that she had been paid, she was informed that Magistrate Marvin Barr had turned over the keys to her landlord. And she asked, so what happens to my money? Magistrate Barr told her to sue the woman. When she found out further, Magistrate Barr had given the keys, and immediately somebody else had been placed into the house. So she took the keys, brought Magistrate Barr on summary for the trial court, and they asked him, and his contention was that Magistrate Ayan was not in the court at the time. They spoke in for the key. They just said they wanted to inspect the house. And the question to him and the summary was, did they return the key when they went to inspect the house? He said no. After the summary was determined that she shouldn't have done that, this lady filed a complaint because she was not receiving her money. She was going up and down. She filed a complaint against Magistrate Barr before the Chief Justice. The JRC investigated and took into consideration all of these attendant circumstances that this woman was now with all her money, with our house, and made a determination. And it is that determination of the JRC that we hereby confirm, and hence our judgment.
Judgment.
This case was called for hearing as Tommy and Dubai, who had Badoko Rockham's Mama and J. Aware Pantanapia, Amnesty Korea, as well as Joseph T. Gibson appear for the respondent. Having carefully reviewed the records, heard the arguments, and considered the relevant ethical principles applicable thereto, it is hereby adjudged that it is unprocedural and arbitrary for the magistrate to interfere in a matter now formally assigned to him and take action to the detriment of either party, and that in an instant case, the respondent magistrate's action to return the keys to the party without reference to the magistrate to whom the case was assigned violated judicial canons 8 and 10. Wherefore, if you have the foregoing, the findings and recommendations of the JRC are affirmed, and the responding magistrate is suspended for a period of 12 months. In addition, order to pay the amount of $1,560 United States dollars to the complainant. At the end of the suspension, if the amount ordered paid is not paid, the suspension remains until it complies. The clerk of this court is ordered to inform the parties of the decision in this year last order. Given on our heads and the seal of the Supreme Court of Liberia, this 18th day of February 2025. Signed, Senino Gideon, Chief Justice, Supreme Court of Liberia. Letter Howard Wolford, Associate Justice, Supreme Court of Liberia. Joseph B. Cabal, Associate Justice, Supreme Court of Liberia. CNN D. Clinton Johnson, Associate Justice, Supreme Court of Liberia. Lord Mr. Justice Yami Open Blessed Student, having decided the determination of this case, while last serving as the chairperson did not participate in the hearing determination of this case, hence he did not sign this judgment.
I don't know what the murmuring is about, or we are getting a bit, impatient now with you counselors. Take note and govern yourself. If you are a magistrate or a judge, act on the status of a matter that has already been settled by your colleague of concurrent jurisdiction. Don't jump in there and have somebody lose that amount of money and or whom. The next time, a magistrate will think twice that matter was not assigned to me, even for one day, even by a telephone call. That magistrate could have called his colleague magistrate to find out the status of that matter. We take it serious here. We take it very serious here. So I don't know where you're coming from. He is indeed suspended for 1 year. Mr. Clerk, call case number 15.
Management of German Technical Corporation GTZ, Cabinet versus Lieutenant Jason Gary Officer and Joe Warren and the others. Release appeal grant of the petition for the judgment, stop the judgment.
Mr. Justice Yusuf D. Kaba will deliver the opinion of the court. Councillors, I don't think we should be warning you all again, because we will just look and pick a name and a face who's talking and will impose the highest fine of $500. So please let's demean ourselves. This is serious business we are doing here.
This is the second time this matter has claimed the attention of the Supreme Court. After hearing it for the first time, the court sent a mandate to the lower court containing 3 instructions to be performed by the lower court. The first one, the court wanted the lower court to do was to determine whether the appellees were employed by the appellant under a contract of indefinite duration entitled to redundancy benefit. The second question that this court certified to the lower court was to determine whether the appellees are entitled to overtime pay. The third one was an option. If the parties did not want these two questions to be determined, the option was the appellee who either refile their complaint with the lower court being the hearing officer in the Ministry of Labor, or amend their complaint that was already before the Labor Ministry. When the matter went down, the appellee elected to amend their complaint. And after the amendment, the hearing officer proceeded to hear the amended complaint. At the end of the hearing of the amended complaint, the hearing officer determined that the appellant here was due the appellee the amount of $177,311.50 as overtime benefits. The appellant disagreed with this finding of the hearing officer, took the matter up for judicial review before the National Labor Court. The National Labor Court affirmed the finding of the hearing officer, and the appellant allows an appeal to this court. Now, this whole matter borders on the interpretation of one provision of the labor practices law, because this matter took place before the promulgation of the Decent Work Act. So the labor practices law governs the matter. And that provision is section 701, subsection 2. And it reads as follows: an employee who on one or more working days of the week works fewer than 8 hours may be required to work more than 8 hours on the remaining working days of the week, but in no case under the provision of this subsection shall the daily limit of 8 hours be exceeded by more than 1 hour, nor shall the weekly limit of 48 hours be exceeded. Now, it is the interpretation and the application of this provision on the facts of this matter that was the subject of the contention. After the court interpreted the provision in this way. Now look, the law provides that a person should not work for more than 48 hours per week. Point. But, and then the working hour per day should be 8 hours per day. Well, a person may work less than 8 hours on any day, with the proviso that you will fulfill the time less in that 8 hours on the other days. But when you're going to do that, you're not going to work for more than 9 hours on any given day. When you work for more than 9 hours on any given day, then that's overtime. So that means you can work for 1 hour to cover up for the hours that you didn't work on certain other days, so as to be able to have the 48 hours working week. Now, in this case, the appellant are alleging, now look, we work for 9 hours from Monday to Friday. So therefore, we are entitled to 5 hours as overtime or pay due us. And the applicant did not give us a 5 hour overtime that we are due. The applicant is saying, no, you didn't work for, that's not how the calculation goes. What happened is, every day, that 9 hours we're talking about, you have 1 hour as lunch break. And that 1 hour has lunch break. The law provides that you are only entitled to 30 minutes as lunch break. So the other 30 minutes, you are not on the company there. So in fact, you are waiting for 8 hours and 30 minutes every week. Then on Saturday, you went from 8 o'clock to 12 o'clock. So when you add up all of the time that you work, that should be calculated as the time that you work, you will not do the calculation will say that you work for 4.5 hours per week, which is less than the 48 hours working day, and therefore you are not entitled to overtime pay. But then we notice that the applicant did not produce any instrument to establish that the appellees went for or had 1 hour lunch every day. They produced no evidence. The only evidence that was available to the court were those that were produced by the appellee, which shows that they come in, they sign 8 o'clock, and they sign out 5 o'clock every day. So there was no evidence to substantiate the allegation of the appellant that these people had 1 hour of lunch. So we say granted. Then let's try to see now how many hours they work for in a week. The 9 hours per day from Monday to Friday, when you calculate it, that means they work for 5 additional hours every day from Monday to Friday. So that 5 hours, you add it to the Saturday, they work from 8 to 12. You add the 5 hours on the 8 to 12, that means they will be working on Saturday from, the Saturday work will be now 9 hours. So that would be more than the 48 hours that the law requires. So only 1 hour per week that they work as overtime. So now, that 1 hour per week must be, the overtime benefit of 1 hour per week must be determined. And then the period of the year that they work, in fact, getting the benefit for that 1 hour must also be calculated to determine the overtime benefit. And when we factor that calculation into the finding of the hearing officer, we saw that the hearing officer was over-calculating the benefits that should have accrued to the applicants. So we decided that we have that formula that should be used to calculate the overtime benefit encapsulated in the opinion, and then have it remanded to the hearing officer to recalculate the benefits of the applicants, and then proceed thereafter as provided for by law.
This case was called for hearing. Councillor Kabiatu called as our vacant appeal for the applicant. Councillors Kuku, Wadoba, Hotel Cry, and Prince Cry appeal for the appellee. Having heard the arguments, review the facts and circumstances revealed by the records, and examine the law controlling it is hereby adjudged. It is the law that what is not denied is being admitted. The applicant being the custodian of the employment records, it failure to produce evidence contrary to the appellee's testimonies of salaries, wages, and tenure of service. The appellant's inaction is an admission of the appellee's evidence. That section 701.2 of the Labor Practices Law provides that, quote, an employee who on 1 or more working days of the week works fewer than 8 hours may be required to work more than 8 hours on the remaining working days of the week, but in no case, under the provisions of this subsection, shall the daily limit of 8 hours be exceeded by more than 1 hour, nor shall the weekly limit of 48 hours be exceeded. Quote. Applying this statute to the facts in this case, it is established that each of the appellee's overtime benefits is 1 hour per week, and that in review of the figures contained in the tabulation of the overtime benefits due, the appellee show that the benefits are grossly overstated. As from our review, each of the appellees is entitled to overtime benefit of 1 hour overtime payment per week. Hence, grounds for remaining for proper calculation. Wherefore, in view of the foregoing, the final ruling of the trial judge is affirmed, however, with modification, that this case is remanded to the court below with instruction to the judge presiding herein to have seen forwarded the hearing officer of the Ministry of Labor to calculate the overtime payment as determined herein. The clerk of this court is ordered to send a mail to the judge presiding in the court below to resume jurisdiction and proceed in keeping with this judgment. Because I will go against the appellant, and it is hereby so ordered. Giving on our hands in the seal of the Honorable Supreme Court of the Republic of Liberia, this 18th day of February, year 2025. Signed, Senine GEO, Chief Justice, Supreme Court of Liberia. Chief Senator Howard Wodokoli, Associate Justice, Supreme Court of Liberia. Yamin Yusuf B. Kaba, Associate Justice, Supreme Court of Liberia. Yamin Boko Senior, Associate Justice, Supreme Court of Liberia. Senior D. Clinton Johnson, Associate Justice, Supreme Court of Liberia.
Court case number 16.
The unconstitutionality of Executive Order number 126, creating the Office of Assets Recovery, is called for judgment.
Madam Justice Chief Etta Howard Wodokoli will deliver the opinion of the court.
The petition filed before us is an in-brief petition challenging the constitutionality of the Executive Order number 126, creating the Office of Assets Recovery. And this petition was brought in because of the nature of the case in brief. The Ministry of Justice was invited to come as per law and as per practice to file his response to the petition. The Anita group of companies, the petitioner hearing, alleges that the Executive Order number 126 was unconstitutional as it usurped the legislative functions by duplicating the roles of the LACC, that is Liberia Anti-Corruption, and the Ministry of Justice, violating 3.341 and 89 of the Liberian Constitution. The Ministry of Justice responded that the President has the authority to issue executive orders under Article 5C of the Constitution to combat corruption. And they also said, in fact, who are you? You lack the standing to challenge the order, as only the LACC or the Ministry of Justice with a certain claim of usurpation. So this court has held that before we go into issues of matter, the first thing we have to determine is the standing. It's jurisdictional, and we say the question here asked by the Ministry of Justice is, did you get a letter patent to represent the LACC or the Ministry of Justice? This case, they said, on our view, we've discussed it, and we've come up that the petitioner had no standing. If anybody had a standing to bring the issue, would be LACC or MOJ. And the issue that we have here it's clearly they're saying that you are usurping the function, the company's court, of the Ministry of Justice and the LACC will say shortly that the petitioner has been standing to come before us because they do not have the legal authority through a letter of patent or otherwise to institute this action. So short as that, we are saying you have been come for LACC and whoever and the Ministry of Justice, we have been standing. So we have dismissed the case on that ground.
When this case was called for hearing, counsellors Ed Winkle's right to liberal basis in the appeal for petitioners. Counsellor Ed Winkle had the appeal for the respondent. Having reviewed the record head, the arguments, contentions, and grounds, and consider the relevant laws applicable thereto, it is hereby adjudged that the petitioner has no standing to assert the interests of third parties where it has not been given authority to do so. It cannot raise the claim of third parties who are not before the court, and that in the instant case the petitioner having failed to sustain the burden that Executive Order 126 for the establishment of the Office of Access Recovery has violated the statute of picture of the statute. It is denied for lack of proper constitutional challenge. Wherefore, in view of the foregoing, the petition brings for an order of this court declaring Executive Order 126 unconstitutional is hereby denied and it is hereby so ordered. Given on our hands and seal of the Supreme Court of Liberia, this 18th day of February 2025. Signed, CNATO, Chief Justice, Supreme Court of Liberia. Chief Senator Howard Wolcott, Associate Justice, Supreme Court of Liberia. Joseph B. Kabal, Associate Justice, Supreme Court of Liberia. Yami Koko, Senior Associate Justice, Supreme Court of Liberia. CNN B. Clinton Johnson, Associate Justice, Supreme Court of Liberia. Preventing Ethics Committee report of complaint filed by Magistrate Teresa W. Dami Cash Chukon Elie against Councillors Councillor M. Musadin and Anthony Orlando Tamar is covered judgment.
Two associate magistrates filed this complaint against the former Minister of Justice, and he was then Minister of Justice and Attorney General, and the county attorney, the city solicitor of the RIA Magisterial Court, alleging that these two officials of the Ministry of Justice had abused their positions and had gone ahead to nullify prosecute their case at the RIA Court against a purported relative of Councillor Musadin, whom they had gotten an arrest order for the alleged commission of the crimes of theft of property and criminal mischief. Suffice it to say, in keeping with policies, the Chief Justice referred the complaint to the Grievance and Ethics Committee, who found that these two officials of the Ministry of Justice properly nullified the case because this court has said, and it is the law, that the Ministry of Justice has the sole prerogative to end cases, issue indictment, change indictment, non-prosecuted cases for one or more persons, and we cannot dictate, the courts cannot dictate when and against whom they can non-prosecuted cases. So we are in agreement with the grievance and ethics committee that these two people acting within the field of the law regarding their respective positions, that is to non-prosecute the complainant's case against whoever she was complaining against for theft of property and criminal mischief. And we are affirming the findings and recommendation of the GPC, and there was no unethical transgression here by either officials acting in their respective capacities.
In this case, was called for hearing Councilors J. Howard Duncan, who are double battle of Muslama, and Tony Luba, via Namisi Gray, Councilor Frank Musati Jr., and the Abrose for this comment. Having carefully reviewed and considered the arguments and considered the relevant ethical principles applicable thereto, it is hereby adjudged that the statutory and decisional laws extend in this jurisdiction, hence the prosecutor and Tony the authority to file a leave of court with dismissal of the indictment of the count contained therein as to either all or some of the defendants, given that it is the prerogative of the state to determine whom they will prosecute for the commission of the crime, whom they will exonerate from prosecution, or whom they will enter another prosecution, and that no court can or should question the state for entering another prosecution in favor of anyone complainant's case against Mr. Serena McGill being within the pale of the law and the purview of the state. The act of the respondents, while serving as prosecutors, does not constitute a violation of the Code of Ethics and Professional Conduct. Hence, the Supreme Court confirms the recommendation of the GEC. Wherefore, in view of the foregoing, the recommendation of the Criminalizing Ethics Committee is affirmed. The clerk of this court is ordered to inform the parties of this court's position, because at this allowed and it is hereby so ordered. Given our hearings in the seal of the Supreme Court of Liberia, this 18th day of February 18, 2025. Signed, Sayine G.O. Chief Justice, Supreme Court of Liberia. It is Eto Howard Wolokodi, Associate Justice, Supreme Court of Liberia. Yusuf B. Kaba, Associate Justice, Supreme Court of Liberia. Yami Kogokwe, Senior Associate Justice, Supreme Court of Liberia. CNN D. Clement Johnson, Associate Justice, Supreme Court of Liberia.
Before we go to part 2 of today's session, let me, in this public manner, on behalf of the entire bench, express our thanks and appreciation to our amici curiae for this term of court, Councilors J. Alia Banka, Kuku Y. Dobor, Batu Holmes Farmer, and Tommy Dugba. We thank you for the dedication which you apply to your research of the various JIC and GEC cases that were handed down this day. Thanks a whole lot. It made our work easy. So on that note, let me also recognize some of our retired and former Chief Justice and Associate Justices of the Supreme Court of Liberia, in no certain order, but I was first called the name of retired Chief Justice Francis S. Cockball, Senior. Thank you, CJ. Mr. Justice M. Wilkins Wright. Madam Associate Justice Felicia Coleman, and last but not the least, Mr. Justice Kabina M. Janet. We appreciate you all being here for these closing ceremonies. We see the former judge of the National Labor Court, retired Judge Comfort Nat, and we see the retired judge of the 8th Judicial Circuit, also here, retired Judge Don. We welcome all of you here today. I hope that there isn't other judges. Who is it that are Richard? Oh, Gillian. Judge Gillian, you are welcome. You are welcome. We are happy to have all of you here today in pursuit of our fraternity, whether you are on the bench or off the bench, and whether you are a judge or not a judge. Thank you for keeping up the bonds of this fraternity. So without much ado, we will call on Mr. Justice Yusuf D. Kaba to deliver the opinion of the court regarding the admission of 61 attorneys at law as counselors at law.
Our legal jurisprudence set a standard that recognizes categories of lawyers practicing in our courts. Attorneys at law and counselors at law. Attorneys at law, graduates of recognized law schools, while treated and recognized as lawyers for the practice of law after satisfying section 17.1 of the new Judicial Law Revised Code 1972, are, however, prohibited from appearing before the Supreme Court as lawyers. Their prohibition or legal disability can only be lifted by satisfying the requirements under the new Judicial Law Revised Code 17.6, which provides as follows. Any attorney who has been actively engaged in the practice of law for 5 years may submit a petition to the Supreme Court showing his moral and professional qualifications for membership in the bar of the Supreme Court and praying admission as a counselor of that court. The petition shall be supported by the affidavit of at least 2 practicing counselors of the Supreme Court, one of whom shall present a petition to the Supreme Court in open court. If the Supreme Court accepts the petition, the Chief Justice shall appoint a committee of at least 3 counselors of the Supreme Court who, as soon as convenient, shall examine the petitioners and report in writing upon his moral and professional qualification to the Chief Justice. In addition, the petitioner shall take and satisfactorily pass a written examination on questions that a lawyer in practice before the Supreme Court may reasonably expect to meet, which shall be prepared and conducted by the National Board of Bar Examiners. If the petitioner has satisfactorily passed the examination, and if the report is favorable, the report shall be voted upon by the members of the bar of the Supreme Court present at the next sitting of the court. And if the majority vote for admission, the petitioner shall be admitted as a counselor at law before the Supreme Court. That's section 17.6. The rules of the Supreme Court forbid attorneys at law who have met the requirement above to appear and present matters before the Supreme Court. Under this provision, the applicant here today, wanting to become members of the Supreme Court Bar, have petitioned this court that they are Liberian citizens who have been admitted in their respective county bar as attorneys at law, that they have practiced law for 5 years or more, that they are in good standing with their respective county bars and the National Bar Association, that they are of good moral and professional characters, and that the allegation of facts as are contained in the petition are supported by affidavits of 2 councillors of the Supreme Court Bar. These attorneys, therefore, pray to this court for admission to the bar of the Supreme Court of Liberia as members. Our section of the records of past petition of many applicants who petitioned this court for admission as member of this bar was, in many cases, laden with flaws. These were contrary to elementary procedural requirements laid down by this code in numerous opinions, such as procedure for withdrawals and amendment of petitions, the required signatories signing affidavits, and appropriate documents as evidence of citizenship. The current petitioners have demonstrated that they took note of our criticism of past flaws as raised in our previous opinions on admission of candidates, and have conscientiously proceeded, thereby avoiding these lapses and flaws that were the subject of this court's disapproval. The Supreme Court, in its strive to ensure the expeditious hearing of cases and the court rebranding effort, has departed from calling each petitioner to be examined in open court and opted to call for a meeting to review the applicant's petition. Predicated upon this, the Supreme Court commenced the inspection of the petition filed by the attorneys at law who believed that they had met the legal qualification that prohibited them from appearing before the Supreme Court. After thoroughly inspecting the 76 applicants' petitions, the court, through the Chief Justice, appointed 2 committees: the Examination Committee, headed by Councillor G. Moses Fega, and the Moral and Ethics Committee, headed by Councillor T. Nibagni Warner. These 2 committees were charged with examining each candidate's intellectual capacity, further, in determining each applicant's moral and ethical fitness and appreciation of the ethical responsibilities, duties, and obligations expected of them. Others appointed on the Examination Committee are Councillors Philip A. Z. Ben II, Stephen B. Dunbar Jr., Duel Green, Dr. Jara A. Babu, Johnny Mogo, Benedict F. Sano, and Jamal C. Detro Jr. And others appointed on the Moral and Ethics Committee are Councillor Cyril Jones, F. Joa Lawson, Ruth M. Japa, and Danielle M. Hyder. The court forwarded the names of 76 candidates out of the 84 petitioners to the committee for written examinations in civil and criminal procedure laws, constitutional law, contract, commercial, and corporation law, and oral and written ethic interview and examinations. Several candidates, including senior government officials, judges, magistrates, members of the Office of Public Defense, and prosecutors, applied to the court for dispensation. A decision by the court to grant dispensation is not novel or unique in our jurisdiction. As far back as 1997, this court, speaking through Mr. Justice Emmanuel Red, of seated memory, spoke to the issue, quoting Mr. Chief Justice James A.A.P.A., also of seated memory, and in 2021, this court reaffirmed this holding that every applicant for admission to practice in the Supreme Court shall be required to prepare and file a petition which shall be voted upon by the Supreme Court bar, and he shall be expected to pass the bar examination in keeping with the requirement of the rules, except in those cases where lawyers are appointed and commissioned by the President of the position, which require them to practice before the Supreme Court. We find this in 20 LLR 748. Further to the above, the authority to grant dispensation is also in furtherance of the authority granted this court by Article 75 of the Constitution to promulgate rules to regulate lawyers appearing before it and subordinate courts. This court is not oblivion of the fact that the purpose of the examination is to ensure that lawyers practicing before the Supreme Court possess the requisite knowledge, skills, and arts in the law to contribute to the positive evolution of the law and enhance public confidence in the rule of law and the judiciary as the last hope for men on earth. As always, the court, in the exercise of its discretion, meticulously examine each application for dispensation on a case-by-case basis, taking into consideration the peculiar status of each applicant, and with due care to grant said dispensation, considering that its selection should not contribute to the erosion of the quality and industry expected of lawyers practicing and appearing before the Supreme Court. 8 candidates, therefore, were granted dispensation. The names of the 8 candidates for whom the court granted dispensation were forwarded to the Committee for Ethic Review only. At this junction, we note that the committees constituted by this court to examine the analytical capacity, legal knowledge, skills, and moral fitness of the candidates for admission to the Supreme Court bar submitted a consolidated report dated January 17, 2025. The report informs this court that of the 76 names forwarded to the Committee for Written Examination and Ethic Interview, 51 candidates were tested in legal writing skill, analytical ability, and knowledge of our legal practice and procedure, using several subject matter to provide factual context, while 10 candidates cite the moral and ethics only. The report also submits that 7 applicants did not pay the exam fees and therefore did not sit the exam, while 8 candidates failed the written examination but passed the ethics examination. Accordingly, the report recommended that for admission to the Supreme Court bar, the names of 61 applicants, or 80.26% of the 76 candidates who wrote the examinations, and the 8 candidates to whom this court granted dispensation. To whom this court granted dispensation, the following are the names of applicants recommended by the National Board of Bar Examiners, commencing from with the names of 8 candidates given dispensation for admission to the Supreme Court bar. So I will call the names. Jacob T. Emmanuel Barry, Joseph C. Perry, John B. Sacco, Alex T. Johnson, Rosetta C. Nante Jacobin, Peter K. H. Wanyak, Thomas Preston Bumble, J. Nelson Freeman, Stephen J.C.S. Kai, Andrew Nimle Ropeland, Joshua S. Pula, Abraham Tamba Bori, the first, Kamara Bafule A.M. Kamara, Marvin S. Bach, John Alvin Blackie, Melvin Chidi, Dilate Sayer, William Matthews K. Bangalu, Alan Musa Beliti, Julius S. Brown, Edward B. Dunn, Sayine M. Dixon, Urias S. Gold, Joseph K. Fayad, Rennie O. Moses, Benson B. Smith, Nimatu Kamara Richardson, Lawrence Swart, James N. Delinet Jr., Sam Nia Harris, Celestine H. Howard, T. Celestine H. Howard, Carter B. Simon, Daniel S. Tamba, Robert Jawar Green, Randall D.M.O. Johnson, Jose K. Suba, Daniel D. Dolo, Adolphus B. Brown, J. Quio Dennis, Daniel C. Gieco, Hannah Armstrong Kekela, Bani F. O. Kiau, Philip G. Wega, Benedict A. Yasia, Yeni King Allen, L. Ben Naku, Aina Kapu Ala, Eric M. Kamara, Sidi Fuma Kamara, Ya Vala Pau, Emmanuel Archie Port Sr., Philomena Tube Williams, Sensi Senwa, T. Sensi Senwa, Naomi M. Gray, The committee made a number of other recommendations for consideration by the scope in enhancing the future administration of examinations to attorneys applying for admission to the Supreme Court bar. They recommend for this court consideration as follows. 1. That this court considers announcing the commencement of activities for the admission process to the Supreme Court and constitute the two examining bodies at least 4 months before the dates of the examination. In the opinion of the committee, this will afford the candidates adequate time to prepare for the exam and raise funds to pay the cost of the exam, and the two committees will adequately prepare and execute the mandate of the court. After carefully considering this recommendation of the two examining bodies, observing the substance of their report, and noting that some candidates did not sit the exam due to their inability, and that the report of the two examining bodies was relatedly filed with the court, we are inclined to grant the committee's recommendations as follows. The court, having established in recent opinion the time of the examination to be in November, the Chief Justice shall constitute the two examining bodies and announce the commencement process of application for admission to the Supreme Court bar in the first week of August of each year. This court should consider organizing a structured program of support for lawyers to enhance their legal writing and analysis and analytical skill through periodic seminars, workshops, and etc. This court is aware of this observation of the committee that many lawyers have difficulty with basic legal writing and analytical skill. In addressing this same recommendation in 2021, this court will find that a well-tailored continuing legal education program will in general contribute to enhancing the writing skill, professional and ethical standard of members of the bar. We therefore hereby place at the disposal of the Liberia National Bar Association the expertise and the facilities of the James A. Pierre Judicial Institute in the development of training modules for a comprehensive and well-tailored formal continuing legal education program that may be incorporated into our rules and made a requirement for obtaining a certificate of good standing. The Liberia National Bar Association will further engage the board of the Judicial Institute in drawing up modalities to execute this program. The committee recommends that this court consider stabilizing the fees of $1,200 United States dollars for this year's exam, as that to be paid for the next 2 years or for such period as the court will determine. We have searched other common law jurisdictions and found no standardized fee for the bar exam. The cost is determined for every exam. However, due to the economic reality of Liberia, we now declare that until otherwise decided by this court, the fee for applicants applying for admission to this court's bar is set forth at United States $1,200. The court expresses gratitude The court expresses gratitude to the members of the National Board of Bar Examiners who, after thoroughly assessing the applicants, submitted a consolidated report recommending the admission to the Supreme Court Bar of the successful attorneys at law. In light of the above, we hereby endorse the committee's recommendation for the admission of the 61 candidates listed herein. The court congratulates each successful attorneys, especially attorneys Stephen J.C.S. Kai, Andrew Nimne Rople, and Joshua S. Kula, who in the 2 examinations administered by the committee. The audience have validated the Supreme Court's quorum. Wherefore, in view of the foregoing, and by the power vested in us as Chief Justice and Associate Justices of the Supreme Court, we hereby grant the petition of the above listed candidates, admitting today 61 attorneys into the ranks of this Supreme Court Bar, Republic of Liberia, as counselor at law and with the rights and privileges appertaining thereto. The clerk of this court is ordered to issue to each of the attorneys named herein a counselor certificate with the signatures of the Chief Justice and Associate Justices of the Supreme Court affixed thereon, duly satisfying that they have been admitted to the bar of the Supreme Court and are permitted to practice law before the Honorable Supreme Court of Liberia. And it is hereby so ordered.
The Supreme Court having convened and reviewed the petitions filed on behalf of attorneys at law, upon being satisfied, forwarded the names of 76 attorneys at law to the examination bodies for appropriate testing. After a careful examination of the report from the examining bodies as to the successful petitioners, being satisfied that the recommendations of the examining bodies for the admission of the petitioning attorneys to consulship of the Honorable Supreme Court of Liberia are consistent with law controlling it is hereby adjudged that the petitioners' petitions for admission as councillors of the Supreme Court Bar should be in same and hereby granted, and making 61 attorneys into the ranks of this Supreme Court by the Republic of Liberia as councillors at law and with rights and privileges appertaining thereto. Wherefore, in view of the foregoing, the clerk of this court is ordered to issue to each of the attorneys named herein his councillor certificate with the signatures of the Chief Justice and Associate Justices of the Supreme Court affixed thereon, duly certifying that they have been admitted to the bar of the Supreme Court and have permitted to practice law before this honorable court, so this honorable Supreme Court of Liberia, and it is hereby so ordered. Giving on our hands in the sea of the honorable Supreme Court of the Republic of Liberia, this 18th day of February 2025, signed Seine G.O., Chief Justice Supreme Court of Liberia, James Etta H. Wunukori, Associate Justice Supreme Court of Liberia, Yusuf B. Kaba, Associate Justice Supreme Court of Liberia, CNN G. Clinton Johnson, Associate Justice Supreme Court of Liberia. Note, Mr. Justice Yami Kogo, Senior, having participated in a review of petition filed out of the bailiwick of the Republic, hence he did not sign this judgment. So at this stage, we will now call up Councillor G. Moses Pega, Chairman of the Examination Committee, for presentation of candidates for admission.
Let's start there.
Thank you. Madam Chief Justice and Associate Justices of the Honorable Supreme Court of Liberia, as a point of departure in performing the task that has been involved on me, I should like to, for and on behalf of members of the committee and in my own name, express our thanks and appreciation for the honor done to us by affording us the opportunity to serve. For affording us the opportunity to serve. Without further ado, I humbly and delightfully present to you, Madam Chief Justice and Associate Justices, 61 candidates who have heretofore been named and who have passed successfully the examination administered by the committee for admission to this bar of the Honorable Supreme Court of Liberia, a court of the near result in our jurisdiction. Thank you very much.
So at this stage, with the admissions of attorneys at law and subsequently,
And so the candidates will be called, and we want to admonish all of you, as you heard the justice say, in the Supreme Court or in any court, we don't clap. So there should be no clapping here, please. We also ask the councillors sitting in the front row to please do us the honors, because you know they have to stand and then their councillors stand behind them. We believe that is going to be a little bit inconvenient for you.
And we ask that when your names are called, kindly bring your oath with you. We're now going to have you repeat it after us. We want it to be your own oath. One thing we say there is I, and you continue with your name and state the oath.
Thank you.
We have Stephen K. Andrew Minette Rockland, Joshua S. Pula, Ibrahim Kamal Bori 1, Bafure A.M. Kamara, Bobby S. John A. Melvin Cheney,